Hey everybody. Okay, week 10. A lot going on this week. Kind of doubled you up with some stuff that is going to make it a little bit more, uh, give you a little bit more to do. And I apologize for that, but to make the semester work out, I kind of had to do that. What we did in our work last week was the draft of the victims' rights. And here's what I'm looking for in that. There's some issues within the victims' rights. I mean, it's a great idea to compensate, to protect, and to give that platform to discuss or to talk about the impact of the particular crime on the individual victim. And but there's some issues there. The first thing is who should get compensation? Should it be anybody that's a victim? And although of the 20 or so that I've graded or looked at so far, only a few talk about this issue, but it's a really important issue, especially when you look at some of the restrictions. And that's one issue where you can do some analysis and some development. The second area is how much. And how much should somebody get? So, say they have a $100,000 loss, should they be fully compensated by us, by the people? It's not the person who has committed the crime that is providing us compensation. It's a pool of money that comes from several different sources, including tax revenues. I believe also some of the revenues that come from citations, the penalty assessment. If you've gotten a traffic citation recently, you've come to realize that a traffic citation is only about $100, and then probably 2.5 times more for penalty assessments, which go to various funds. So, it's not the bad guy or the suspect that's compensating the victim. This is almost like an insurance fund. So you need to look at that. And then, is this something that should be expanded? Now, that's part of your analysis. Remember, if you provide your opinion, oh, this is a great idea and should be expanded, and I think that's probably not very authoritative unless you're a subject matter expert. And then if you are, you need to lay out why you're a subject matter expert beyond the fact that maybe you received compensation at some point. All things that you should consider in this. So those are some of the issues that I'm looking at. When you look at the impact statements, the issue is whether or not it is prejudicial against the defendant and unfairly prejudicial against the defendant. Some of you are making a really, really big mistake in talking about when that impact statement comes into play. And so I'm going to leave that there, but make sure you have a good idea about how it's going to work. That's going to be in your final paper, also due this week. This week you have a multiple question, multi-guess exam with a short essay, I believe, at the end is your last question. Be much like the one you had last time. So make sure you give yourself plenty of time, and I would get on the work really quick this week so that you can get it out of the way and you don't find yourself Sunday night trying to do two things at once, write and take the test. That being said, let's talk about arrest through arraignment. A person gets contacted by the police, and this can be either from a traffic stop to stopped because they are a suspect in a recent crime, or with a warrant that has been obtained by investigation or by a patrol officer who's following up on his case from the beginning to the end. So the person is arrested. Thing to think about is the idea of Sixth Amendment rights and when do they attach. The federal side, we know. The state side, there's also a time when it attaches, when the rights attach. In California, California is much more stringent on the police, on government, than the federal government rule is. So I'd probably have an idea of which is which and know what the rules are. The issue, one of the issues that's talked about in the book is the quality of an arrest. Arrest must be supported by probable cause. And I know of an agency in LA County that, for some reason, that whole probable cause thing is kind of moves back and forth, and probably should have some, greater discussion in the process, and more scrutiny by the district attorney's office. But it must be supported by probable cause. The arrest, the report should lay out that probable cause and not just say, saw a crook, arrested sane, and have that probable cause so that the DA can then work with the case. And that comes also when it comes from an investigator. And DAs complain all the time about police reports coming from particular agencies. And if you're going into law enforcement, that's why I make you write. I want you to write, I want you to learn how to write, I want you to learn how to concisely and clearly get across your point. You've probably noticed that I really like logical, sequential kind of things. In this week's discussion, I'm talking about the development of the law, and then talking about the issues, and then talking about developing those issues into other areas. So, police reports can be, very poorly, put together. In California, you have the arrest, and then if a person is held in custody within 48 hours, they have the right to what's known as a McLaughlin or probable cause hearing. And what that is that in California, officers write down the probable cause in a brief fashion on a form, which then goes with the person who's been arrested when they go to real jail. And this document then goes to the an ALJ, an administrative law judge, who isn't really a judge, but they're a person who's gone to law school and has passed a hiring process and is now in the working for the county that assesses these probable cause. McLaughlin, Riverside versus McLaughlin, City of Riverside, City and County, I think it is, versus McLaughlin was a California case. And then there's an East Coast case, and many times in big cities, an officer, no matter the time of day, will take the arrestee directly to the judge, where the probable cause is discussed. In California, ALJ looks at it by themselves, usually in a small little cubicle room in the bottom of the jail, and then decides whether probable cause exists. Now, if they don't like the probable cause, they can release the suspect at that time. If it's within 48 hours, let's say they get the probable cause deck, and then when there's 47 hours expired, well, more than likely that person's going to be released. They'll call the police station and say, hey, this doesn't cut it, and this is what we need to make this work. So the initial appearance or the probable cause hearing not necessarily the initial appearance, can be really important. California, the initial appearance is the arraignment. And arraignment occurs in within 48 hours, excluding weekends and holidays. So if a person's arrested on a Friday night, even though more than 48 hours elapse, they need to be arraigned 48 hours from the arrest, excluding those days. So at the initial appearance, several things are discussed. Make sure you know those, because I think you're going to see some of those things. And they're really important issues that happen at the initial appearance. At the initial appearance, the defendant will find out exactly what they're charged with. Any police reports will then be released to the defense counsel. If there's no counsel, then they're available for the defendant to take if he's pro per or pro se and is representing himself. So really important factors in the whole charging process. We've talked about the discretion of the prosecutorial discretion in that area. So that'll give you a chance to look back on that whole charging thing. There's a case I'm following right now, which a person has apparently stolen multiple thousands of dollars of money. And it will be interesting to see, will the DA put these all together as one, or will they attempt to charge multiple counts of grand theft? The idea is that you bury the defendant in potential liability, or exposure is the term, then you can get a guilty plea, plead guilty to lesser charge to avoid this really huge exposure. One thing that's also talked about that we will see is the idea of bail and when bail is available. Remember, bail, there's no right to bail. There's a right that bail cannot be excessive. If it's excessive, then the defendant has an Eighth Amendment claim. So make sure you have that distinction. No right to bail, but bail cannot be excessive. That is a constitutional issue. In the case of a felony, once you have arraignment, within 15 days in California, a preliminary hearing is supposed to take place. And often it will take place in a long time later, weeks, days, even months. And that whole idea is the fact that there's delay. We'll talk about delay later in the semester. Preliminary hearing is an evidentiary hearing where the the prosecution has to put on enough of a case to establish probable cause that the case should be heard at trial. Now, one thing I kind of messed up on here is between arraignment and preliminary hearing is a chance for motions to be heard. And the motion that we're most interested in is the motion to suppress. Have the police done something in their investigation where the Fourth, Fifth, or Sixth Amendment have been violated? So that's where you see the motion to suppress. After arraignment, before preliminary hearing. Once that issue is decided, then the things that are used in the preliminary hearing must be lawfully obtained. And a judge will then decide whether or not the case should go to trial. The term of art is called bound over. Is the person bound over for trial? And then there's another track that we go through, and that track is the grand jury. Now, grand jury is kind of cool, because what can happen is a person who's not in custody, who's under investigation, the DA can go to the grand jury and present their case and the case will be such that or will be the prosecution side. Defendant's not present, defendant's counsel's not present, the defendant can be called to testify, and if he is, he doesn't have counsel with him. Counsel can't object to what's asked. All the defendant can do to protect themselves is their Fifth Amendment right against self-incrimination. So another thing that's exclusive, we haven't, in this way, it's, no arraignment's taken place. The person hasn't been officially charged. So any evidence can be used at the preliminary or at the grand jury hearing. Now here's where we run into problems. And it happened in Ferguson, Missouri, in the Michael Brown case, where the DA took the information from the investigation to the grand jury and presented it to the grand jury. And people were having a fit that the grand jury didn't convict the officer. That isn't the purpose of the grand jury. All the grand jury does is review the evidence and see if there's probable cause to take the case further, take it to trial. Grand jury hearing, there's no preliminary hearing, and then the case would proceed to an arraignment in the trial court. So, those are the steps. Be really careful with grand jury. Kind of a pet peeve of mine, because I hear people say, oh, why wasn't he convicted? That wasn't the purpose of the grand jury. Question you might ask yourself, though, is why would the prosecutor go to the grand jury in a case like Michael Brown and not just look at the evidence? And there was a significant amount of evidence that said that the shooting was not a violation of statute, meaning it wasn't illegal. So, with those in mind, think about what was intended there, and what happened. So, with that, good luck on the exam. I hope you all rock it out, and get your papers in. Get it done early. Don't wait on it. I don't want you sitting there Sunday night at 11:59 trying to submit stuff and then losing points because it's not in. Okay, with all that, good luck in the exam, and we'll see you in